Attorney Ali Kasahoon here from Tropic Legal. I often get asked the question, what is the eviction process in Florida? So let's go over a broad overview of what that is. In Florida, a landlord can terminate a tenancy for any number of reasons, including the non-payment of rent. In order to terminate a tenancy, the landlord must first give the tenant written notice. The tenant will then be given the opportunity to cure the reason that the landlord is trying to evict them for. If the tenant does not cure the reason that the landlord is trying to evict them for, the landlord can then sue the tenant for eviction. This is done by serving the tenant with a summons and complaint. Once the tenant is served with the summons and complaint, the tenant has 5 days to file a written answer to the complaint and deposit money into the court registry. The days are counted based on the date of service by the sheriff or the date of the posting on the door, not by the mailing from the clerk. The 5 days begin on the day after the tenant was served and does not include weekends and legal holidays. If the tenant is contesting the eviction by filing an answer to the complaint, the matter will be set down to be heard in front of a judge and the parties will go to court. Both the landlord and the tenant will have an opportunity to present their cases before the judge. If the landlord wins and gets a judgment for possession, the court will issue a final 24-hour notice. This notice is called a writ of possession and it's given to the sheriff. The sheriff then posts this notice on the tenant's rental home. The tenant then has 24 hours to move out. Again, I'm Ali Kasahoon of Tropic Legal. Thanks for tuning in, and we'll see you on the next video.